So, good morning, Lord Anderson.
Morning, Lord.
The link, the live stream is working for those that have the direct link to it. Those who do not will not, unfortunately, by clicking on Court 71, get the direct live stream. So that would be members of the public who don't know, because I'm told the judiciary website is not properly updating, and it's showing the link for this case in Court 75, where we were yesterday. I'm very sorry about that, but everything is being done by judicial IT to make sure that it is rectified. But does anybody have any objection to continuing on that basis? I can't do anything about it at the moment. I'm very sorry.
No, Lord.
Right, then thank you very much, and we will proceed. Or you will proceed.
Indeed, Lord. I'm going to try, in fairness to others, to complete my submissions within an hour. That may require a following wind, but I shall do my best.
And we will give you that following wind.
Well, perhaps neither of us should be too rash with our promises, but Lords, we were on the second limb of the proportionality test, the issue of whether the government had established a rational connection between the designation of Mr. Shvidler on the one hand and the objective of the regulations on the other. And you've already had my submissions on what we say was the first error of the learned judge under this head, the adoption of what I call the collective rational connection heresy that was perpetrated by Sir Ross Cranston in the Dalston Projects case. I'd started on my next submission that the learned judge took too deferential an approach to the issue of rational connection, and that's my grounds 3A, 3B and 3C. You have my points already on the standard of review more generally, and on what we say are the errors of approach in paragraphs 91 and 92 of the judgment. Those errors, we say, were compounded by the hands-off approach that the learned judge took to assessing the ways in which it was said that Mr. Shvidler's designation would contribute to the objective of the regulations. And if we turn to paragraphs 93 and 94 of the judgment, you can see how the expression of those ways evolved. First of all, in paragraph 93, you see the three bases that were relied on in the amended SDF, in the original explanations for the designation. Strong political message, may incentivise the government of Russia, and signalling the UK's support. And that is, we say, in contrast to the amended bases that you see in 94, which are certainly fuller and we suggest more ingenious than the originals. So you see in the original formulation at 93, there's no reference at all to Mr. Abramovich, for example. Indeed, there's no reference to any of the indirect chains of connection that appear in paragraph 94, particularly if you look at 94, 1, 3, 7, and 8. We accept that the word incentivise in the original 2 is potentially quite a broad word, but certainly nothing is spelled out in relation to the intermediary influence, which is, in a way, the basis of the revised formulation.
I mean, do you accept the first sentence of paragraph 95? What Sir James argued there?
We do, Lord, yes.
Yeah.
And I'm going to address that. I mean, what seems to have happened, or what did happen, because we know this, is that when the legal challenge came, officials and lawyers sat down to have another go, the outcome being the paragraph 94 bases. And those bases are recorded in that form, both in the response, which is the formal detailed grounds of resistance type document, and in the witness statement of Mr. Reed, which stated them but offered no elaboration of them. He called them assertions. That is what happened, as we know, from the response to our request for further information. And I took you to that last night. I won't take you back to it. It's supplementary bundle, tab 12, page 231. And indeed, my learned friend accepts in his skeleton argument at 42 that the reasoning is that of, as he puts it, SCDO officials, as opposed to the Secretary of State personally. He says nothing turns on that, but that that is accepted. We accept, as Lordship just asked me, that a respondent to a claim founded on proportionality is permitted to rely on grounds that were formulated after the decision under review. That's the misbehaving case. But we don't accept that the very high measure of deference displayed, for example, at paragraph 116 of the judgment is appropriate in these circumstances. And I'll summarise my three reasons for that very briefly. My skeleton argument has dealt with this at 54. The way I express the reasons is like this. First, the respondent did not rely on any secret or confidential evidence. There's been no application for a closed material procedure. Plainly, that would be one of the factors were it present, which would encourage deference. Secondly, the evidence that was adduced about Mr. Abramovich's relationship with Mr. Putin is scant, and to the limited extent that it is up to date, it is based on open source reporting. And the high points of that evidence were summarised by the learned judge at paragraph 111 of his judgment. And you can see there, the learned judge had regard to the evidence on which the Secretary of State relied in designating Mr. Abramovich as strongly supporting the proposition that the close relationship between him and President Putin continued. But when he sets out the high points of that evidence, you see that the first item is a nomination for a second term as governor in 2005. He was given a medal in 2006, 2010, 2012, 2014. Putin was reported to call Mr. Abramovich our oligarch. Pictures in 2016 and 2017. And then he says, perhaps most importantly, in 2022, Mr. Abramovich was requested by Ukraine to help negotiate an end to the Russian invasion of their country, and it was credibly reported that President Putin personally approved of his involvement in peace talks with Ukraine. And he says on that basis the Secretary of State was entitled to conclude that there was a continuing relationship of trust and confidence between President Putin and Mr. Abramovich. Well, the only thing there that is up to date is the reference to the reports of involvement in peace talks with Ukraine, and indeed Mr. Shvidler also made reference to those reports in his own evidence. He said he doesn't talk to Mr. Abramovich much anymore, and when they do talk, they don't talk about these sorts of things, but he did himself also refer to those reports. So it is what it is, and it's out there, it's open source, and it is not indicative of any bulging Foreign Office file on Mr. Abramovich, or at least not one that was deployed in the context of this designation process. Then the third point I make, I touched on already, the 8 revised bases were prepared by lawyers and officials for the purposes of litigation, and they were not based on any primary evidence that had not been available to the Secretary of State at the time of the original and revised designations. And we know that from the response to the request for further information. So we accept that the court may have regard to these assertions, to quote Mr. Reid, and the reference to that is in our skeleton of 53. But we submit that the court should not give them any special deference. And the court has in front of it effectively the same material, or the court had in front of it the same material as the decision maker did, and it's entitled to form its own view of whether the Secretary of State established that the designation, if I can quote Lord Reid in Bank Mellat, could reasonably be expected to realise the objective at least to some extent. So that's our second submission under this head, too deferential an approach. With that I come to our third and more substantive submission, that the government has simply failed to establish a systematic contribution to the desired objective, which was the formulation of Lord Sumption in the Lord Carlisle case, and therefore failed to establish a rational connection. There are 8 factors now to look at, and the short answer on each of them is that the idea that designating this British-American citizen, who's not been to Russia for more than 16 years, could have any influence on the war in Ukraine by any of the means asserted is no more than vague and unsupported speculation. And where fundamental rights are at stake, this is not good enough. There is nothing remotely enough to establish a systematic contribution to the desired objective, and indeed, if we need to come on to fair balance, there's nothing like enough to justify the devastating effect that these sanctions have had and continue to have on Mr. Shvidler and his family. If I could start, as the learned judge did, he grouped helpfully the factors, as indeed we had done in our skeleton argument. And he pointed out at paragraph 107 that the first, third, seventh and eighth factors relate to incentives to third parties. So this, in a way, is the new reasoning that came in when the litigation commenced and the justifications were reformulated. And he looked at those together. Your Lordships will have a tab open at paragraph 94, where these 8 factors are set out. And he started at 108 of his judgment with the first of those factors, which is that the designation would incentivise the claimant to put pressure on Mr. Abramovich to encourage President Putin to cease or limit the government of Russia's action in Ukraine, to distance himself from and therefore isolate President Putin, and/or speak out against the Russian invasion of Ukraine. So they're really hedging their bets on this one. It's a sort of thing we lawyers like to draft. They're considering all the possibilities. That they're trying to establish that there might be an incentive to put pressure on Abramovich, but as to what Abramovich was going to do in response to this pressure, well, who knows? It seems he might encourage President Putin to pull out of Ukraine. He might distance himself from President Putin, or he might himself speak out against the Russian invasion of Ukraine, all of which it's said are desirable possibilities. And the threshold difficulty with this submission is that it is contrary to the scheme of the Act, Section 11 of the Act, and the regulations in our submission. I think it's common ground to designate someone on the basis that they are an associate of an associate. It's common ground that it was not open to the government to designate Mr. Shvidler on the basis that he was an associate of Mr. Abramovich and Mr. Abramovich was an associate of Mr. Putin. And of course, he wasn't designated on that basis. Nor, of course, did they designate Mr. Shvidler on the basis that Mr. Abramovich was promoting the war in Ukraine. That was the original allegation, but that was dropped by the time we come to the decision under review. And you'll remember that the connection with Abramovich was treated as a valid ground for designation only to the extent that Abramovich had himself been involved with Evraz and extractive industries, transformed industries in Russia. Our submission is that the government cannot evade that admitted limit on the statutory scheme when constructing a justification for Mr. Shvidler's designation by ascribing a role for Abramovich as a mutual associate of both Putin and Shvidler that could not form part of the designation. So that is our primary and self-standing point in relation to the first, third, seventh and eighth factors. But there's a more general objection to all 4 of those factors, all of which rely on the possibility that designating Mr. Shvidler might encourage, incentivise or disincentivise other people to do things. You'll remember how the rational connection test is defined by the Supreme Court. 2 formulations. Lord Reed, Bank Mellor 116, could the designation reasonably be expected to realise the objective, at least to some extent? Then Lord Sumption in Lord Carlisle at 34, is the measure capable of contributing systematically to the desired objective? The objective, of course, not being the sending of a signal or the signalling of support or the influencing of some intermediary, but the longer range objective of encouraging Russia to cease actions destabilising, undermining or threatening Ukraine. And in our submission, those tests are not satisfied by something that could best be described as hit and hope. The judge thought at 118, the way he put it there, was that designating Mr. Shvidler may well discourage others from getting involved in Russian business. Even that first stage of the analysis is no more than speculation. Perhaps someone who was thinking of getting involved in Russian business might see Mr. Shvidler's name on the list and think, well, I better be careful about associating with Russian businessmen. But so what? How would that encourage Russia to cease actions destabilising, undermining or threatening Ukraine? The chain of causation is impossibly long and impossibly tenuous. And that is strengthened by the fact that, as we know, these intermediary formulations were dreamed up once the litigation had begun. The first, third, and seventh and eighth factors, we say, are a lawyerly construct. They are simply too indirect and theoretical to meet the standards set by Lord Reed and Lord Sumption for a rational connection. We come then to the second and fifth factors, reproduced in paragraph 94 of the judgment, which are very similar. The second is sending a signal to the claimant and others in his position that there are negative consequences to having implicitly legitimised the government of Russia's actions by associating with individuals who are close to President Putin and who have carried on business in sectors of strategic significance to the government of Russia. And then five, very similarly worded, send a signal to the claimant and others in his position that there are negative consequences to having implicitly legitimised the government of Russia's actions by carrying on business in sectors of strategic significance since the illegal annexation of Crimea in 2014. So that one is negative consequences of having carried on business yourself since 2014, and the first one is about associating, even more indirect, with people who have carried on business since 2014. Both are about sending a message. And the learned judge addressed those at 121 to 122 of his judgment. And he says there in 121, the claimant argues that sanctions cannot permissibly be imposed as punishment for past acts now regarded as objectionable, and there is no rational connection between this step and the aim of the 2019 regulations. It is said that the claimant had already done all he could to withdraw from whatever indirect association the Secretary believed he had with the Russian government, and to denounce publicly its actions in Ukraine. I'll take you to that shortly. The signal cannot make any meaningful contribution to achieving the objective of ending Russian aggression in Ukraine. And in response to that, at 122, the learned judge doesn't accept the argument. He says any sanctions regime is likely to be backward-looking, focusing on past actions, not then unlawful. And the 2019 regulations refer expressly to past conduct as providing the ground for designation. To be effective, sanctions need to send messages. The value of such messages persists, even if the person in question ceases the conduct complained of and makes statements distancing himself from the regime. So his point is that any sanctions regime is backward-looking, and of course he is right that the numerous thresholds for the application of sanctions expressly include past as well as current behaviour. But, Lords and Lady, to leave it there, we say, is to fall into the error that crossing one of the thresholds is enough to justify the imposition of sanctions. It's an easy error to fall into when you read these regulations, because they no longer include the appropriateness test is a statutory nullity, and they don't refer at all to proportionality. And you can see how easy it is to slip into this error. Lords, if you look at the claimant's skeleton below, core bundle tab 10, page 142, paragraph 28 of that skeleton argument. First, the starting point for the court's proportionality analysis in a case such as this must be that the person concerned satisfies the statutory designation criteria. That indicates that there is a substantial public interest in maintaining sanctions on a person. Well, this is a Secretary of State's skeleton argument by the time the case got to court, which is eliding the satisfaction of the statutory threshold criteria with the existence of a public interest in maintaining sanctions. And when you think of the, I think I said yesterday there'd be many thousands of people who are potentially subject to sanctions. My instructing solicitors pointed out that we're well into the millions. And if you look at all the people employed by all the companies in Russia that engage in these extractive techniques and all these other industries and so on, and you look at the breadth of association and so on, it simply cannot be the case that crossing the threshold is enough to imply a substantial public interest in being sanctioned. It's a very easy mistake to make, and we say that is really the error that the judge was falling into here. And the point is that you can't just look at Regulation 6 in isolation and say, oh, it's backward-looking. You have to look at the objective of the regulations, and you have to look at the principle of rational connection and the requirement that the designation could reasonably be expected to realise the objectives, at least to some extent. So, although a designation may be founded on past conduct, it needs to be justified by its potential to influence future conduct. And that is really our point. And in that respect, they are distinct from criminal sanctions. Sanctions may be punitive in their effects. I'm sure Mr. Shvidler would agree with that. But they are not penal measures in the sense that they are intended as punishment for past conduct. If they were, they would be subject to the whole panoply of protections under Articles 6.2 and 6.3 of the European Convention. And indeed, to the extent that they were based on conduct which was perfectly unobjectionable at the time, they would contravene Article 7 of the European Convention. The reason they don't constitute punishments in law is on the basis of their objective to influence things in the future. And sending a message that the government disapproves of things that were done in the past is not sufficient without that extra ingredient. And Lords, on that point of sanctions not being penal, could I refer to paragraph 59 of our skeleton argument, where the point is made, and then there is a little footnote, footnote 20, in which we say the point has not yet been considered in the post-Brexit domestic case law, but is well established under the pre-Brexit EU case law, and we cite a case that my learned friend relies on, and the authorities cited there. So I don't think I need to take you to that case on that point. What these factors do not say, the second and the fifth factors, is anything about the capacity of this designation to achieve its objective. Indeed, by designating someone who had already withdrawn from the connections that are now considered objectionable, even though they were not considered objectionable at the time, that's of course Mr. Shvidler having resigned as an executive director, and someone who indeed had publicly denounced the war in Ukraine, the designation sends a perverse message that you might as well behave in ways that we don't like, because even if you change your ways, we will designate you anyway. Might as well be hanged, as they used to say, for a sheep as a lamb. The fourth factor, Lords, again looking at 94 of the judgment, is to incentivise the claimant and others in his position to speak out and oppose more robustly Russia's invasion in Ukraine. And the starting point here is at paragraph 18 of the judgment. This is the story is being told. So at 17, the claimant resigned with the majority of the other directors on the 10th of March. Then on the 12th of March, a statement was made in The Guardian on Mr. Shvidler's behalf. His spokesperson said, Mr. Shvidler would like to make it clear that, like the rest of us in Europe, he is hoping and praying for peace and an end to the senseless violence in Ukraine. We all hope that the war can be brought to an immediate end. So he referred to senseless violence, and you might think he referred rather bravely to the war in the Ukraine, a word, of course, not favoured in Russia, where the approved terminology was and is special military operation. He was plainly aligning himself to the European position, as he called it. And again here, I should take you to the evidence on this subject, which was referenced in our skeleton argument below. We didn't quite find room for it in our 25 pages, but if I take you to the core bundle at 126, page 126, tab 9, paragraphs 58 to 60. So 58 sets out the fourth factor. It says it's a reference to the suggestion made for the first time by Mr. Reed that the defendant did not consider that the claimant's public and published statement in opposition to the war was in sufficiently robust terms. Then the quote in The Guardian is referenced, and the point is made that Mr. Shvidler has explained to the court with graphic and precise supporting evidence the risks that he was running of retribution from the Russian state even by making such a statement. And you can imagine Litvinenko, Skripal, and so on are referenced. And you see the references there to his second witness statement, which is in the supplemental bundle now at tab 13. I don't take you to that witness statement now, but you have the references there so you can follow them up. Mr. Reid subsequently backtracked in part, acknowledging the legitimate concerns identified by Mr. Shvidler as to the potential risks associated with speaking out against the Russian invasion of Ukraine, but continuing to suggest that the claimant should make some undefined steps to oppose Russia's invasion of Ukraine in private. There's a reference to the second statement of Mr. Reid, that's supplementary bundle tab 14. This is an extraordinary suggestion. The claimant has sought over the past 15 months actively to engage with the Secretary of State with a view to ascertaining what, if any, further steps it is considered that he ought to take. The defendant has not responded at all to any of these approaches. And see 1 Shvidler and 2 Shvidler, that's supplementary 9 and supplementary tab 14. This lack of engagement sits ill with the defendant's suggestion that the claimant would be able, if incentivised by the imposition of sanctions, to make a meaningful or systematic contribution to ending the war in Ukraine by means of private opposition. And if they really thought that some private intervention by Mr. Shvidler could help end the war in Ukraine, why do they not respond to his approaches on this score, saying, what is it exactly that you'd like me to do? Let's talk about it. Not even a response to these repeated approaches. And at the end of paragraph 60, in any event, given the uncontested evidence that the claimant has no connection or influence over Mr. Putin, has never been involved in politics, and has absolutely no ability to influence or affect Russian government policy, it's fanciful to suppose that such a thing would be possible. So that's the fourth factor. Well, so that just leaves one, perhaps the oddest of the factors at paragraph 94 is number 6. It's suggested in number 6 that the designation of Mr. Shvidler would incentivise the claimant and others in his position to divest from businesses in sectors of strategic significance to the government of Russia, thereby disrupting their operations. Well, the problem with this is, first of all, as one has seen from the argument on previous bases, in particular 2 and 5, the Secretary of State is, or the government is very hot on past involvement being a sufficient basis for sanctions. And if you've been involved, particularly since 2014, then you are potentially in the frame. So it seems a little odd, on the one hand, to say how backward-looking it is, and then on the other hand, to say that the designation of Shvidler, partially on the basis of things that happened before 2005, might incentivise others to divest from businesses. And then the second problem is that an asset freeze does what it says on the tin. It does not allow you to divest from your businesses without committing a criminal offence, because you're not allowed to have funds transferred to you in exchange for your shares. So for both those reasons, really, number 6 just doesn't work. Mr. Shvidler did disinvest, and 10 days later sanctions were imposed on him. If anything, his example could be said to demonstrate that disinvesting is pointless because it will not avert sanctions. So in summary, under this head, the considerable effort that has been put into thinking up possible rational connections after the event has produced only meagre rewards, and these factors in our submission do not come close to satisfying the tests of Lord Reid or Lord Sumption. Well, that just leaves my last 2 grounds, alternative measures and fair balance. Alternative measures is dealt with in the judgment at 129 to 131, and fair balance, well, no, I'll stay on alternative measures, and it's paragraph 4 of our grounds. The reference in our own skeleton is at 65 to 66. And it's fair to say that the point has not had the same prominence that's been given to rational connection and then to fair balance. But nonetheless, it is the basis on which Lord Sumption found in Bank Mellat, it was one of the bases on which he found that the direction failed the proportionality test. That was how that case was explained, as you remember, by Lord Reid. at 125, he referred to the apparent adequacy of lesser measures in relation to banks that he considered to be in a comparable position. We would accept that some weight must be given to the considered judgment of the government as regards the relative efficacy of various measures. And of course, our first submission is that no measures are needed at all, because there is no basis for believing that Mr. Shvidler has or could have any conceivable influence on the conduct of the war in Ukraine. But the learned judge stepped much further back in our submission than he should have done when he expressed the approach in the terms that he set out in 131. He said, under this head, this is an area where the courts have to defer to the judgment of the Secretary of State. The relative benefits, disadvantages and effectiveness of different measures taken in pursuit of foreign policy objectives is not one on which the court can second-guess the Foreign Office. All that can properly be said is that the government's analysis is not self-evidently irrational or outside the range of reasonable responses. And we contrast that with Lord Sumption, Bank Mellat, paragraph 20, the classic formulation of the four-limbed proportionality test, which he prefaced by saying it required an exacting analysis of the factual case for each of those four limbs. This means, in practice, that if the government's case, well, I should say the alternative measures basis arises, of course, only if the government's case survives the rational connection analysis. But if it does so, even if only to some small extent, the court is entitled to ask itself, and should ask itself, whether the supposed rational connection, even if it is assumed to be a good one, will add value to the other ways in which messages are being sent, or could be sent, to the government of Russia. So, for example, as we say at paragraph 66 of our skeleton, you might think that if supplying weapons and military training to tens of thousands of Ukrainian soldiers does not send a message to the Russian government, then it's not perhaps practical to imagine that sanctioning such a peripheral figure as Mr. Shvidler in their contemplations would do so. And even if some action were justified to put pressure on Mr. Shvidler, why did it have to be the full force of designation? After all, Evraz itself was subject to an asset freeze in May 2022. Mr. Shvidler's shares in Evraz were worth £30 million or so. They were frozen when Evraz was sanctioned. And if sanctions against Mr. Shvidler really were justified, could they have stopped at transport sanctions against his planes, or his planes and his yacht, which sailed under the Bermuda flag and was thereby eligible for transport sanctions? That would have allowed Mr. Shapps and the Foreign Secretary to send their signals and send their tweets without imposing separation and dislocation on Mr. Shvidler's family, and without paralysing his business activity. But there is no sign that such less restrictive alternatives were even considered. Lords and Lady, finally I come to ground 1E, which is fair balance, and that's at judgment paragraphs 132 to 145. It's the fifth of my grounds of appeal, and it's dealt with in my skeleton at 67 to 70. It's the last of the steps under the Bank Mellat test, and the question, as Lord Reid remarked in Bank Mellat at paragraph 74, is in essence whether the impact of the rights infringement is disproportionate to the likely benefit of the impugned measure. And as he also acknowledged at paragraph 126, this was one of the bases on which Lord Sumption and the majority found the direction in that case to be disproportionate, on the basis that the direction would make little, if any, contribution to the achievement of its objective. So if the designation passes the rational connection test, and if the court does not feel able to pronounce on the adequacy of alternative measures, the fourth step provides another basis on which to gauge its proportionality. Our case remains that no public benefit is to be expected from the designation, but if to some limited extent the court were to disagree, that speculative benefit, such as it is, would have to be weighed against the concrete hardships affecting the appellant and his family. You already have our general submissions on judicial approach. I don't repeat those. In addition to those, we've identified three specific errors in the approach of the court to this issue, which are summarised in our grounds at CB2 and in paragraph 70 of our skeleton. It might just be convenient to look at our skeleton, paragraph 70. And you'll see that the first relates to the issue of British citizenship, the second relates to temporary and reversible, and the third is, again, the Dalston Projects heresy, but this time in its fair balance iteration rather than its rational connection iteration. So I need to say nothing more about the third, but let me tell you what I can about our case on the first and second. So the first error relates to the consequence of Mr. Shvidler's British citizenship. And to be clear, we accept that the Secretary of State knew by the time of Mr. Shvidler's designation that he was a British citizen. That obviously wasn't known at the very start. We saw from the data subject access requests that they seemed to assume he had other citizenships. But of course they knew by the time of his designation that he was a British citizen. But what we do not accept is that the Secretary of State, or those acting on his behalf, had properly weighted the significance of that in terms of Regulation 3 of the regulations. That being, as you will recall, the provision that sanctions have extraterritorial effect, with the result that even in America there is an obligation to obtain licenses from OFSI for any purpose. And you see that from the Supplemental Authorities tab 7, which is the revised SDF of 11th of November at page 106. And this is a section I don't think we've yet looked at of the original designation, headed ECHR compatibility and proportionality. And there is, with respect to a strong element of boilerplate in that these sections appear in very similar form across a range of different designations. And if you look at what's said about proportionality in the last paragraph, it says it is acknowledged that sanctions may have a serious impact on designated persons, particularly in relation to accessing assets within the UK jurisdiction and in relation to travel to and from and residence within the United Kingdom. In the present context, we understand, based on information from the Home Office and open source research, that Shvidler holds UK citizenship alongside US citizenship and spends a substantial amount of time in the UK. So they certainly knew he was a UK citizen. We understand that Shvidler's children have attended UK fee-paying schools. We recognise that if Shvidler is in the UK when sanctions are applied, or seeks to re-enter the UK, the asset freeze will impact his ability to withdraw funds and access essential personal services in the UK, thereby significantly impacting upon his ECHR rights and Article 8 rights in particular. And our point is simply that that is not a full expression of the position. That, no doubt, is the boilerplate that would apply in the case of somebody who wasn't a UK citizen, because the sanctions apply to citizens of any country while they're in the UK, but there is no acknowledgement there of the extraterritorial effect of Regulation 3, and therefore no indication that this factor was taken into account. Now, my friend points out, quite correctly, that Mr. Reid acknowledged the correct position in his witness statement, but that was after we had pointed it out in our appeal. The witness statement post-dated the revised designation, and we'd drawn the point to the government's attention in the grounds for review that accompanied our appeal, Core Bundle tab 14. So the best evidence is that the implications of Mr. Shvidler's citizenship were not taken into account by the SCDO when making their proportionality assessment. The second error relates to the description of the sanctions as temporary and reversible, on which the learned judge placed some reliance. They were in our submission neither temporary nor reversible. If I start with temporary, our submission is that the sanctions are indefinite in their application, not temporary. That was the word used in the Belmarsh case, and it's appropriate here too. nobody knows how long these sanctions might last for, but it doesn't look as though they're going to be ending anytime soon. If I take you to my skeleton argument at paragraph, at page 41, at the bottom, I have a footnote on this to the proposition that the government's own statement suggests existing Russia sanctions serve aims that are liable to be achieved, if at all, only in the long term. And we quote two things on this. The first is a ministerial report to Parliament, which was relied on by the Secretary of State in his response, saying the policy intention is that sanctions on Russia will remain in place until the UK government is assured that Russia has ended its illegal annexation of Crimea and Sevastopol, withdrawn from eastern Ukraine, and is no longer carrying out actions that undermine Ukraine's sovereignty and territorial integrity. And the government introduced that document, and you see that it's in the core bundle. Subsequent to that statement, the purposes of the 2019 regulations have been broadened further, such that they may also be maintained for the purpose of promoting the payment of compensation by Russia for damage, loss or injury suffered by Ukraine as a result of Russia's invasion of Ukraine. And that's, if you remember, the addition to Regulation 4 that was inserted in June 2023. So that's why we make that submission on indefinite. Why are they then described as temporary? Well, the word appears to have had its origins, certainly judging from my friend's argument, in EU law. But the difference there is that sanctions in EU law are of strictly limited duration and have to be renewed if it is wished to continue them. Indeed, for relevant purposes, sanctions are renewable annually. So that's why they can be described as temporary. Can I take you to two authorities, one English and one European, I can now say. The English one is, I believe, the only Russian sanctions case. It's in tab 39 of the authorities, page 1830. It's Boris Mintz, the Court of Appeal. I believe the only Russian sanctions case to have come before the Court of Appeal to date. So we should have a look at that. Tab 39, page 1830. The decision of the Chancellor, Lord Justice Newey and Lord Justice Popplewell, and it came out on the 6th of October. Then the issues in the case are distinct from this one, but if you look at page 1832, you can see that they're set out in paragraph 3. Can judgment be lawfully entered for a designated person by the English court following a trial at which it's been established that the designated person has a valid cause of action? That's the entry of judgment issue. Then there was a licensing issue relating to the licensing of the payment by a designation person of an adverse costs order. And then thirdly, there was the issue of whether a designated person controls an entity within the meaning of Regulation 7, where the entity is not a personal asset of the designated person, but the designated person is able to exert influence over it by virtue of the political office that he or she holds at the relevant time. So you see the significance of that one, particularly in the conclusion arrived at on page 1892, where you see in the very last lines of the case the words, Mr. Putin could be deemed to control everything in Russia. And there has been further authority on that point. It doesn't concern your lordships, but I simply show you that because that is why people know about the Boris Mintz case. But can I direct your attention to one short passage on page 1878. It's the sidelined passage, paragraph 181, and the Chancellor is approving a point made in argument by Lord Justice Popplewell, 4 lines down. However, as Popplewell LJ pointed out in argument, and Mr. Rabinovitz KC accepted, the stay might well be for an indefinite period because no one could say how long the sanctions against the claimants will last. So he was rejecting the submission that any stay of proceedings would only be temporary because the sanctions would only be temporary, and he was preferring the word indefinite, which we also urge on the court. That's all I take from that case. The other relevant case, it's again one that was relied on by the Secretary of State, paragraph 62 of his skeleton, is the judgment of the General Court of the EU, tab 48 of the authorities bundle, a case called Ez against the Commission. And we entirely accept that this is a case in which sanctions are described as temporary and reversible, or at least limited in time as reversible. So I take you to paragraph 209 of the judgment, which is where the General Court is considering a set of arguments, including a proportionality argument. And my only friend likes this because it says that it rejects the proportionality argument, in particular because, first, those measures are by nature temporary and reversible, see paragraph 79 above, and do not therefore infringe the essential content of the right of property. And that's paragraph 79. If we look at that, it says the effects of those provisions are limited in time and reversible. The freezing of assets provided for in them must be applied in accordance with Article 5 of Decision 2011-172 during a specified period, and the Council, which keeps it under constant review, may at any time bring it to an end. And if we look at paragraph 7, that article is set out. As you can tell from its title, the decision dates from 2011, and indeed you see from paragraph 1 that it was adopted on the 21st of March 2011. Paragraph 7, this decision shall apply until 22nd March 2012, and incidentally shall be kept under constant review even within that period. So the court is explaining why it describes the sanctions as temporary in terms that simply do not apply in this jurisdiction, where they are indefinite and very likely there for the long term. As to reversible, we submit that these sanctions are no more reversible than a prison sentence is reversible. Of course, a designation can be revoked. It is reversible in that narrow sense, but the consequences of sanctions cannot be reversed. There's no question of putting someone in the position they would have been in had designation not happened. Indeed, you'll remember that compensation is only payable in cases of bad faith, and limited even then to £10,000. Well, in relation to the issues of detriment and hardship, I opened with some reference to that, and I don't want to take you to the full suite of evidence on the subject, but could I just ask your lordships to note where that evidence is? It's the first statement of Mr. Shvidler, the supplementary bundle, tab 9, pages 180 to 188, paragraphs 64 to 82. And it's the second witness statement of Mr. Shvidler at supplementary tab 13, pages 305 to 324, paragraphs 174 to 227. And could I just take you to three short passages from the first witness statement in the 9th supplemental bundle. The first is at page 182. The simple point I want to get across is that this is not a Bank Melak case where the only right at issue was Article 1 of the first protocol, and the issue was how serious was $25 million in the context of a bank with 2,000 branches around the world. This is a case also on Article 8. It's also about private life and it's about family life. And sanctions do not just have a financial effect, they have what one might call a moral effect, or a life-changing effect. And I'd just like to take you to three very short passages of the evidence that establish that. The first is on page 182, and it's paragraph 71. where he's just been explaining how his children's lives have been turned upside down by their exclusions at a very sensitive time, particularly for Anna, of her education. His former wife and he took the difficult decision to have the children finish school in the United States. And then he says, as a result of my designation and consequent press coverage of my designation, my name is incorrectly synonymous with Russian invasion of Ukraine. And that, in our submission, is an important point. And you only have to look at the press coverage of this case, of this hearing, and you look at the comments below the line, and you see what Mr. Shvidler means when he says that. You throw mud and mud sticks, and it may be that it sticks forever. Then going on to the following page, you see something that he says on the material side. He says at 76, as a British citizen, the effect of the sanctions on me is extreme, in a way that the FCDO does not seem to have properly considered, because I'm bound by them wherever I am in the world. Although I'm presently living in the United States in the home of a friend, and my material needs are being met, any attempt by me to deal with any of my assets, no matter where they are located, will be a breach of the sanctions and a criminal offence. So he was a businessman, and he cannot do business. He cannot deal with any of his assets. So that's how he expresses that. And then the last reference I want to take you to is at 188. And he says at paragraph 82, the longer the sanctions are in place, the greater the impact on me and my family. I applied for and became a UK citizen in 2010 as me and my family liked the UK. We settled down and were happy. I used my resources for positive purposes. It's reference to charitable causes. The good reputation I've built over the years has now been shattered, as has my faith in the UK. My younger children have had their education disrupted and their lives uprooted. My elder children are afraid to have dinner with me in a restaurant in case they're accused of breaching sanctions. Well, they could well be, even in America, if they paid for his dinner. People I've employed for years who I deeply respect have had to be made redundant, not because I no longer need their services, but because it's illegal for them to provide me with the benefit of their service. Long-standing personal and professional relationships have been cut off in an instant and may be completely irreparable. So, Lords, it's not just about money, it's not just about Article 1. This is, and it indeed is conceded to be by the Secretary of State, an Article 8 case as well. Well, Lords, the witching hour is approaching. All I want to say, in conclusion, is that the designation of Mr. Shvidler in our submission was arbitrary, and in the words of Lord Sumption in Bank Mellor, paragraph 27, disproportionate to any contribution which it could rationally be expected to make to its objective. For all those reasons, we ask you to quash it. And unless I can assist further, those are my submissions.
Thank you very much, Lord Anderson. Mr. Bethel.
My Lords, my Lady, this appeal, for which the judge below gave permission, starts from the same position as Mr. Shvidler's appeal, Samler and the regulations, but none of the appellants in this appeal has been designated. They each had an interest in a motor yacht called the Fee, which has been detained in London in reliance upon a power elsewhere in the regulations. The Fee came to the UK lawfully before the 2022 invasion of Ukraine and was detained in March of that year. That was a decision taken personally by the then Secretary of State, the Right Honourable Grant Shapps MP. The detention was maintained by Mr. Shapps in April 2022 and again by his successor, Right Honourable Mark Harper MP, in January 2023. And we've been told that the Fee is the only vessel ever detained in this way. I'll start with the scope of the appeal and the principles running through it. After that, I'm going to turn to the legislative scheme, the essential decision documents and the grounds.
How long have you agreed to be with your colleagues?
Well, my Lord, Sir James says that he needs to be on his feet at 3:15, and I will do everything I can to ensure that he is on his feet at 3:15.
Thank you very much.
My Lord, first then the appeal and the principles. This is not a challenge to the legislation under which the yacht was detained. It's not suggested that the legislation is incapable of being applied compatibly with the Convention. In principle, powers of detention, properly used, may be a valuable part of the UK's diplomatic posture. And the exercise of those powers, though not a forbidden area for the cause, is one where the Secretary of State will point to some helpful authorities about intensity of review and the margin of discretion. And the court has been through a number of those authorities with my learned friend Lord Anderson yesterday and this morning. The Respondent's skeleton argument, paragraphs 23 and 24, makes some points about that under the heading deference due to foreign policy decision making. And they cite Al-Rawi and Carlyle, both of which cases Lord and Lady looked at. If the court would just quickly turn up Carlyle, which we have in the authorities bundle at tab 28, page 1480. Paragraph 20 there. And the court will see that Lord Sumption there refers, instead of deference, to the degree of respect for the judgments of the executive, just below D. And he takes that from Lord Reed in Bank Mellat. And in my submission, that's perhaps a more helpful formulation than deference. It emphasises the flexibility required from the court, depending upon what is in issue, depending upon how you would characterise the question that is before the court, rather than the label foreign policy as deployed in my learned friend's skeleton argument. Develop that very briefly just with one further authority, which is the Belmarsh case, which we have at tab 15 of the authorities bundle, page 674. And we're at paragraph 29 with Lord Bingham talking about the question of whether there is a public emergency threatening the life of the nation. If I could just invite the court to read that paragraph 29.
Could you give me the page again?
674. Lords and Lady will see throughout that paragraph, Lord Bingham refers repeatedly to the question that the court has before it, and he characterises in that instance as a preeminently political question. That is why it would be a very rare case that succeeded on limb 1 of Bank Mellat, because the question of sufficient importance is always likely to have a strong political flavour. In any event, we have Al-Rawi, paragraph 147, and the margin of discretion that we heard about yesterday, and that reflecting, firstly, the specialist expertise, and secondly, the democratic accountability of the executive. Now, that margin goes to the exercise of the power, not to its purpose. And the power that we are concerned with is one conferred and delimited by legislation. To that extent, there is a contrast from the prerogative power to make diplomatic representations that was in fact being considered in Al-Rawi. But in any event, the detention powers are controlled by rationality and by ECHR proportionality. And where fundamental rights are engaged, as they are here, the court should look closely at what has been decided by the decision maker and why, and in particular the courts are well placed to scrutinise the legal question of whether there is a rational connection between the action taken by the government and the objective that it must serve. And as an adjunct to that, whether it can be safely concluded that the decision maker has used the power for the purpose that Parliament intended. The principles that run through the appeal are in 5 short points in very brisk outline at this stage. 1. The power to give a detention direction is a discretionary one, and so it can only be exercised for a proper purpose, namely to promote the policy and objects of the legislation conferring the power, which in turn are identified by interpreting the legislation. That's the Padfield principle as elaborated in a case we have in the bundle called Sparth Home, which we'll go to later. 2. Detention is an interference with the peaceful enjoyment of possessions to which the appellants are entitled pursuant to Article 1 of the First Protocol, A1P1. So that article is engaged, and the detention is contrary to Section 6.1 of the Human Rights Act, unless it can be justified by the respondent as a proportionate measure taken in pursuit of a legitimate objective. And it's not the case that the legislation itself seeks to strike the correct balance. So the Bank-Mellap 4-stage analysis is the task that has to be undertaken. 3. A decision to detain is reviewable on ordinary public law grounds. The decision maker must take account of Wensbury relevant factors, must exclude Wensbury irrelevant factors, and make sufficient inquiries to inform him or herself to the Tameside standard. 4. Where there is a requirement to state the grounds for a detention, that must, as a minimum, explain the basis of the detention. I will take the court to the South Gloucestershire case for that in due course. Now, that requirement does not need to go as far as a statement of reasons. And the duty to provide reasons, as my lords and my lady will be well familiar with, is always context specific. But it's not enough to say, even where the requirement is to state grounds, that that X decision has been made. There has to be some account of why it has been made, why a power has been exercised. And 5, there is a difference between, on the one hand, contemporaneous grounds or reasons, and on the other hand, what might be termed retro reasons, post facto rationalisation. And the court should be cautious in its approach to the latter. But in any event, the starting point is going to be the contemporaneous documents that show how the decision was reached. Now, applying those 5 points of principle, the appellants say the detention of the fee cannot be justified as encouraging Russia to cease action against Ukraine. This has been, certainly should have been, apparent to the government from the outset. It follows that detention was ordered and maintained for some other necessarily improper purpose and not supported by proper reasons. And even taking the government's case at its highest, the effects of the detention are disproportionate. And we say respectfully that the judge below, Sir Ross Cranston, drew conclusions on all of those points that were wrong. Move on then to the legislation and SAMLA, and I'd ask the court to take up Authorities Bundle 1, Tab 1, starting at page 5. We've been here yesterday. And this is the power. Section 1.1, the power for an appropriate minister to make sanctions regulations for prescribed purposes, including those within subsection 2. Over the page at that's page 6 in the bundle, subsection 5, that explains what sanctions regulations encompasses. And at 1.5e, the court will see impose shipping sanctions, see section 7. Section 7 is on page 17 of the bundle, and at 7.1 little a little 1, regulations impose shipping sanctions if they impose prohibitions or requirements for a purpose including detaining within the UK or controlling the movement within the UK of disqualified ships. And then over the page at 7.8a, we see in this section disqualified ships means ships owned, controlled, chartered, operated or crewed by designated persons or persons connected with a prescribed country. That's what the court is concerned with here. Or a prescribed description of persons connected with a prescribed country. So that's the power. For purposes, I'd ask the court to turn back to section 1. And we have in subsection 2 the purposes for which sanctions regulations, including shipping sanctions, can be made. Relevantly, C and D, the interests of international peace and security, and furthering a foreign policy objective of the UK government. National security is available as a purpose, but is not in fact relied upon here. Then at subsection 3, the Act requires that regulations made under this power must state a purpose that either complies with an international obligation, not relevant here, or is one of those in subsection 2, interests of international peace and security, furtherance of a foreign policy objective. Note also section 2 of SAMLA, now repealed but as originally enacted and in force until 14th March 2022, contained additional requirements for regulations for a purpose within section 1.2. And if the court turns up at tab 2, that's page 94 of the authorities bundle, we see section 2, as it then was, and in section 2 sub 4, the minister making the regulations must lay a report before Parliament explaining in respect of each of those discretionary purposes, and that's essentially why the minister considers carrying out that purpose meets one or more of the conditions in section 1 to A to I. So why the stated purpose of X would assist international peace and security, or would assist at a UK foreign policy objective. Why the minister considers, that's sub B, there are good reasons to pursue that purpose, and C, why the minister considers that imposition of sanctions is a reasonable course of action for that purpose. Moving on then to the regulations, which we have behind tab 4 of the authorities bundle, picking up at page 117. And that sets out the purposes for which these regulations are made, consistently with subsection 1.2 of SAMLA. And the relevant one is at A, which the court can see is encouraging Russia to cease actions destabilising Ukraine or undermining or threatening the territorial integrity, sovereignty or independence of Ukraine. So anything that's done under the 2019 regulations must be for the purpose of encouraging Russia that is the Russian state, to cease actions having that effect in Ukraine. If the government is going to adopt a measure that affects Russian people, or a certain class of Russian people, or a particular Russian individual, the touchstone is whether that is capable of encouraging the Russian state to cease actions, destabilising, etc., Ukraine. And if the government says, for example, that a particular measure is intended or is about sending a message, that must ultimately be a message to the Russian state that it should cease its activities in Ukraine. We can then skip forward to part 6 of the regulations, picking up at page 157 in this tab. In section 6, the regulations is all about ships. Regulation 57 was the originally the sole provision within part 6, and it's about cruise ships visiting Russian-occupied Crimea and the separatist regions of Donetsk and so on. Part 6 was amended to add the provisions that the court is most concerned with in this appeal by the Russian Sanctions EU Exit Amendment Regulations number 4 of 2022, which came into force on the 1st of March 2022. And the version of the regulations that we have in the bundle incorporates those amendments. Over the page at 160, Regulation 57A is the first of those provisions that was introduced by the amendment regulations. And it prohibits entry into British ports for ships that are owned, controlled, chartered or operated by either a designated person or by a person connected with Russia, or with a Russian flagged or registered ship or specified ship. Over the page, Regulation 57B, so that's 2 pages for those working electronically, 162 in the bundle. Regulation 57B backs that up by enabling a direction to be given to prevent entry into a British port. Then, 2 pages further on, 164, Regulation 57C enables a movement direction to be given to pilots, masters or harbour authorities to take steps to secure that a ship, putting it in simple terms, goes somewhere, leaves somewhere or stays put. And a movement direction was given to the master and the harbour authority in respect of the fee, although ancillary to the detention direction that I'll take the court to. Note also Regulation 57C1, and the subparagraphs there. This provision has the same scope as Regulation 57A, the closure of British ports provision. So this can be done in relation to ships that are owned, controlled, operated, chartered, etc., by the same classes of people. Turning on to page 166, and we arrive at Regulation 57D, detention of ships. And that enables a detention direction to be given. I emphasise enables because, again, as with the other powers in this part of the regulations, it's permissive. It enables the Secretary of State to give a direction, provided, of course, that's consistent with the purpose in Regulation 4. It does no more than that. I draw the Court's attention to Regulation 57D3, subparagraphs. Again, this is coextensive with Regulation 57A. So the ships that are kept out by Regulation 57A can be detained if they get in under Regulation 57D. And then subparagraph 5 contains various formal requirements for a detention direction. Notably, C must state the grounds on which the ship is detained, and D, 1, must state that it is given under this regulation. Regulation 57D does not provide for whether a detention direction should be made. And it obviously does not require the Secretary of State to make a direction merely because the ship is Russian flagged or Russian owned or Russian registered and so on. Now, that's the legislation in its own words. There are 4 additional documents that assist in its interpretation. I think the court may have seen 3 out of 4, but possibly all 4 yesterday. And these are in towards the end of the authorities bundle. So the first is the statutory report that was then required under section 2.4 of SAMLA. That's behind tab 51 at page 2248. And I should say that at the time when this report was produced, Part 6 only contained that first Regulation 57, the cruise ships provision. This is the starting point for Part 6. And over the page at paragraph 6 on page 2249, paragraph 6 states the statutory purposes, and they are described in the terms that are in Regulation 4, and then one sees at 7 that this is in the interest of international peace and security and furthering a foreign policy objective of the government of the UK. And then paragraph 8, at the beginning of that paragraph, boils it down. Sanctions are intended to increase pressure on Russia to achieve the outcome of Russia ceasing actions which are destabilising Ukraine or undermining Ukrainian sovereignty. And what's being talked about here at this stage, of course, is the 2014 invasion of Ukraine, specifically of Crimea and Sevastopol. The second aid that we have to interpretation is an explanatory memorandum prepared for the amending regulations in 2022, which added those detention powers into Part 6. That's at tab 53 of the bundle, at page 2257, and towards the end of paragraph 2. These amendments will introduce new shipping sanctions measures for the purposes set out in Regulation 4 of the 2019 regulations. Over the page, at paragraph 7, there's a heading policy background, and you get the gist of that in paragraph 7.4. Then,
this is the explanatory memorandum that goes with which regulations?
This is the
amending regulations.
The amending regulations, number 4.
The regulations are brought in 57 ABCD.
Exactly. So 7.6 and 7.7 explain some changes being made to Regulation 5 by other parts of those amending regulations to ensure that the regulations can get at ultimate beneficial owners who've been designated. And then 7.8 summarises the new powers that are being made available to detain ships. And paragraph 7.10 explains that this instrument is accompanied by 2 statutory reports that have to be published. I can take the court to those now. Next tab in the bundle, 54, page 2262, is the Section 18 report. This is required because the amendments are going to introduce new criminal offences. And over the page, paragraph 11 explains the reasons for these offences. The ability to enforce transport sanctions.
I'm going a tiny bit fast for me. So, paragraph 11. Yep.
Paragraph 11, my lady.
Yep.
At which page?
2263. And it says the ability to enforce transport sanctions through these offences is an important deterrent. The vast majority of global trade in goods is carried on board ships. Maritime sanctions are therefore crucial in achieving the objectives of the Russian sanctions regime, and they are designed to cause significant short-term disruption to Russian shipping, thereby restricting their economic interests and further holding the Russian government to account. And then the next tab, 55, page 2269, we have the other report, the section 46 report, explaining why these measures would meet one of the prescribed purposes. And the court will see that it essentially says, at the beginning of paragraph 8, before you get into the subparagraphs, that it's the same form of words that was deployed in the other report. These regulations are going to introduce new maritime measures which are designed to cause significant short-term disruption to Russian shipping, thereby restricting their economic interests and further holding the Russian government to account. That's the legislation. Turning then to the decision making. There are 3 decisions. March 2022, April 2022, and January 2023. And I'll take the court through those decisions. That's going to take a little time, but it will allow the appeal submissions to be put more efficiently, because we'll be jumping backwards and forwards through the decision documents. I'm going to focus on what the contemporaneous documents say, but I will also show the court what the respondent's witness evidence from Mr. James Driver, the head of maritime security, says. A couple of preliminary points about that evidence on which the judge below put some weight. And for the court to note, just at this stage, those 2 witness statements from Mr. Driver are in the supplementary bundle at tabs 3 and 6. There is no suggestion in Mr. Driver's statements that he has spoken to the relevant Secretaries of State or had any special insight into their thinking about the detention decisions, which were taken personally and on 2 out of 3 occasions without any recommended course of action one way or the other from officials. The other point I should make initially about Mr. Driver's evidence is the respondent's notice says that an additional reason for upholding the decision below is contained in Mr. Driver's evidence, where he makes some remarks about Russian economic and political matters. And I'm going to deal with that under the proportionality ground. I haven't forgotten about it, but I'll come to it later. The first decision then. The fee entered UK waters quite openly on the 10th of December 2021. Just for the court's note, supplementary bundle 1, page 9, that's the witness statement of Captain Booth, page 13, explains that. And that was immediately after being delivered by the builders to attend a yacht awards event. And in February 2022, while the fee was moored in London, Russia invaded Ukraine. I'll ask the court to take up now the supplementary bundle, starting at page 110, that's tab 7. And in response to the invasion, on the 28th of February, the Secretary of State set out to close UK ports to Russian ships. And you see there the second paragraph, the maritime sector is fundamental to international trade, and we must play our part in restricting Russia's economic interests, holding the Russian government to account. Down at the end, further detailed sanctions against Russian shipping are being developed, and further details will be shared very shortly. That's from the Secretary of State, goes to all UK ports. The UK authorities then began to investigate ships that were already in the UK with a Russian connection, then captured by the new legislation. On the 13th of March 2022, Department for Transport officials produced a submission headed options to prevent sailings of ships possibly in breach of sanctions. That is behind tab 10, page 118. And I'll skip through these documents because they're helpful for some context, but they don't go to the decision itself. So paragraph 8 on page 119, you see there's a suggestion that the Secretary of State writes the Harbour Authority to state that the ship, this is a fee, is under investigation, and this would enable the Port Authority to give general directions that vessels not going to be given passage. Paragraph 9, we see that the National Crime Agency are investigating ownership, and then after the redaction, paragraph 12, presentation and handling, taking action against vessels perceived to have a Russian connection, is likely to be received positively by the general public. Onwards, tab 11, page 122, there's a letter sent to the Port of London Authority asking the Port Authority to use its available powers to prevent the vessel's passage on the Thames. Then, tab 13, page 131, the court can see a Maritime and Coast Guard Agency information report. And they think at this point that the yacht is owned by somebody else. The name is redacted, but it's been publicly reported as someone called Mr. Vitaly Kochik. Then we have behind tab 17 of the bundle, page 142, on the 24th of March, the second email on that page, an email from the National Crime Agency, and over the page it identifies Mr. Nemenko, the second appellant, as the ultimate beneficial owner, not sanctioned, and it sums up the position. It says the Secretary of State could issue a detention direction under section 57D(3)(b). Whether such a direction is issued is obviously a matter for your department. Move forward.
Who's this from and to? This is from SOCA Local. Who's that?
Well, lady, this is from somebody whose name has been redacted, who is an operations manager in the National Crime Agency, and it goes to somebody whose name has been redacted in the Department for Transport. Then we move forward to tab 20, page 160. We have an anonymised DFT official emailing some other people, some of whom are anonymised. And it says a submission is to go to the Secretary of State this evening recommending the detention of the fee, subject to the Secretary of State signing off overnight. The court will see in a moment that's in fact wrong. The submission made no such recommendation. The submission is over the page, tab 21, page 161. And this is the cover sheet. The court will see paragraph 2 The grounds for proposing the detention are that it is owned, controlled or operated by Sergei Georgievich Namenko, a person connected with Russia. Then over the page, paragraph 8, omitted considerations. Due to action at pace, we have not undertaken analytical assurances. Page 163, we come to the submission itself. Paragraph 2, recommendation. The Secretary of State is asked to consider the evidence, and if you wish to exercise your powers to detain the regulations, sign the directions. Paragraph 5, considerations, says under the shipping sanctions, you can detain a ship that is owned, controlled, operated or chartered by a designated person or a person connected with Russia. The evidence suggests that the yacht is owned today by Mr. Namenko through Dalston Projects Ltd. And paragraph 6. Under Regulation 57D1 of the regulations, you have the power to issue a detention direction if you so wish. That is an unfortunate turn of phrase because it implies that detention can be done on a whim without reference to any further considerations, arbitrarily, as Lord Anderson put it. And there's nothing said here in this submission as to whether making this direction, detaining this yacht owned by this individual, will contribute in any way, certainly in any substantial way, to the objectives of the Russia sanctions regime. Over the page, we'll see paragraph 10. It says there's a support vessel in Italy owned by the same person. It's not going to be detained because Italy, the European Union, only detains vessels if the owner is designated. And then paragraph 14, under the heading Public Sector Equality Duty, explains that if the decision were made to detain, it would raise Equality Act considerations. Those might be outweighed by the public interest. The decision is behind tab 22, page 179. It's an email, 29th of March, 28th of March, I apologise, 2057. Many thanks for this submission. The Secretary of State has reviewed and is content and has provided the attached signed paperwork. The Secretary of State commented that it is most certainly both in the public interest to detain this ship and to publicise the fact of its detention. The Secretary of State sees no reason for him to board the vessel in order to do this and agrees that a comms opportunity exists simply to attend the location and carry out interviews with the ship in the background. 3 points to note about that. This email is the only contemporaneous account of why the Secretary of State exercised his power to detain the yacht. Again, there is no reference to the permitted purpose under the 2019 regulations. There is a reference to the public interest, perhaps, possibly picking up on the PSED point in the submission, and then it goes on to talk about publicity. The Secretary of State asked for a communication plan, and we find that behind tab 23, page 180. And the court turns forward to page 182. This is the bullet points. The ownership was deliberately well hidden. It carried Maltese flags to hide its origins. There's no basis for that. Page 183. The media quotes that are prepared in advance. Stark warning to Putin and his cronies. We will continue to take action against anyone with links to Putin. The intended detention order is at tab 21, page 165. It is identical to the signed copy, which is in the core bundle, and we can stay with this version if that's easiest for the court. And the court will see...
Sorry, lost the page number. Can you page
165. The court will see detention and movement provisions are in paragraphs 3 and 4. States at the beginning that it's an exercise of those powers in the head note. And then the grounds for detention. The fee is being detained on the grounds that it's owned, controlled or operated by Sergei Georgievich Nemenko, a person connected with Russia. The next day, 29th of January, the detention direction, sorry, 29th of March, the detention direction was served on the master of the yacht by some police officers, accompanied by a photographer. Again, just for the court's note, that's in Captain Booth's witness statement, paragraph 17, supplementary bundle 1, page 11. Shortly afterwards, the Secretary of State arrived with a number of television crews and reporters. And we have a transcript of what he said behind tab 25, page 191. This was posted to his personal TikTok account. It's a yacht which belongs to a Russian oligarch, friends of Putin. It cannot be right that oligarchs, people that have benefited from Putin, should continue to sail in and out of London. Next page, 192, an interview. We've held the ship, which we now know belongs to a Russian oligarch, because we're very clear that we cannot have any benefit to these oligarchs with close connections to Putin. Yes, at the moment the individual is not sanctioned, but we know that the connection is there. I should say the ship was deliberately masked in very, very complex ownership structures, as if to deliberately try to deny the reality of it. Page 193. Talks about somebody who is an oligarch, has made their money through their association with President Putin, whilst he's going into Ukraine and causing lives and suffering like nothing we've seen since the Second World War. Now, Mr. Driver seeks to explain what was going on here. The court can find that in the supplementary bundle behind tab 3, page 58. And this is paragraph 78.
So I didn't get the page.
57, and then
Thank
onwards
you.
to 58, Lord. And this is the Secretary of State decided to detain and saw a comms opportunity. Mr. Driver says, this is halfway down the first paragraph on page 58. This reflected the political importance of imposing and being seen to impose sanctions on individuals connected with Russia, so the British public could see evidence of the government taking a strong stance. Mr. Driver then goes on to give evidence about Mr. Shaps's quayside statements about the fee belonging to a friend of Putin and so on. That's at page 61, paragraph 88. He says, these statements cannot be treated as reflecting the full reasons for the decision that had been taken. The respondent's evidence then is that these statements reflected at least some of the reasons. Mr. Driver goes on to explain that public policy decisions will often be presented from a particular angle rather than as a comprehensive account of the reasons for those decisions. That's in order, as he puts it, to sell a particular decision to the public. Again, Mr. Driver confirms that whatever is said in public is at least part of a decision, even if it's not comprehensive. Now, it must be right that the Secretary of State was giving some of his reasons for the detention, if not all of the nuances. Because the alternative possibility is an unpalatable one. It's this, the Secretary of State made these public statements without believing them to be true. That's the first decision. There is, however, a coda. At the same time, the Department for Transport evidently wanted to have Mr. Mendemenko designated under the sanctions regime. And the Foreign Office said there was no case for doing that. Just give the court a flavour of that at tab 29 in the supplementary bundle.
Forgive me for taking you back, Mr. Bethel. You showed us paragraph 88.
Of Mr. Driver.
Yes. But don't we need to go on to read paragraph 89, 90 and 91 to put that in its proper context?
Yes, we do, Lord. And those I will come to.
All right. I just wanted in particular to note, if I may, the final sentence of paragraph 91.
In any event, consistent with the rationale.
No, 91, final sentence. First detention decision and second detention decision were not taken for any reasons other than those which were set out in writing in the 8th of April submission.
Well, Lord, it's quite unclear how Mr. Driver is able to give that evidence.
Well, you haven't asked to cross-examine him, have you?
No, we haven't. In his account as to who he's spoken to and how that witness statement comes to be prepared, there is no suggestion that he's spoken to the Secretary of State. Tab 29, page 201. An email at 15:34 begins the previous page 200. This is a few hours after the interviews on the quayside. Department for Transport officials are emailing, and the last paragraph in the first email on page 201. The Secretary of State would like to look at the owner of the fee, Mr. SGN, being sanctioned, but FCDO said that would likely not be possible. Have you put this request to them already? And then the previous page, 200, further up the chain. The first email, 345. We might need to push them again on the fee, given the Secretary of State has been there today. He'd be quite excited about the individual. FCDO said it was unlikely, so we would need to look at other options. For the court's note, there's more of this at pages 205 to 206 at this point. Don't need to go there now. Second decision. In response to the detention, the appellant's representatives wrote to the Department for Transport. And they said that Mr. Nemenko had not been sanctioned, that he was an innocent businessman and yacht owner, and it was wrong to describe him as a friend or a crony of President Putin in his regime. That led to a further decision on detention in April. The materials for that start behind tab 32, page 211. This time in the cover note to the submission, there was a recommendation. Option A, which I'll come to in a moment. Paragraph 2 begins, following previous steers from the Secretary of State.
So which page?
211. So following previous steers from the Secretary of State. And the court has now seen what record there is of the Secretary of State's thinking. There's very little. Paragraph 3 talks about relying on a generic argument that in order to own the yacht, Mr. Nemenko must be a wealthy individual, and it's reasonable to assume, in the absence of evidence to the contrary, persons of wealth who are residents or located in Russia are connected to the regime by patronage or in a position to influence Putin and the administration. We've found no evidence to either prove or disprove this. So, the author of the submission acknowledges at the time there's no evidence one way or another that Mr. Nemenko is connected to the regime or capable of influencing it. And the recommendation responds to a steer from the Secretary of State, which seems somewhat circular. The Secretary of State has steered his officials in this direction, and so officials then recommend that he goes there. Over the page, Paragraph 11, page 212. Omitted considerations again. Due to the nature of the steer, there are no value for money, state aid, or analytical assurances. The first decision said that this was being done at pace, and so there were no analytical assurances. Now it's because the Secretary of State wants to do it anyway, it appears. No records of steer provided from the Secretary of State to officials have been disclosed. The submission itself is at page 213. Paragraph 6. The detention direction will stand indefinitely until such time as you opt to withdraw it, either following a change in circumstances or if it is no longer relevant. Paragraph 7. Foreign Office has been asked to designate, but no further evidence has been found, has yet been found, linking Mr. Nemenko to the Russian regime. It might be more accurately put as no evidence rather than no further evidence. Over the page, paragraph 10, the options. Option A, maintain detention direction while seeking further evidence. Now, it appears to be a reference in my submission back to paragraph 7, which said that there was no further evidence yet found linking Mr. Nemenko to the Russian regime. Paragraph 13, we have presentation and handling again. Detention of the Fee Guard of national and international media attention. There appears to be support from the UK public for sanctions, and could be a negative reaction. There was seen to be a rolling back of measures. What the court can see this time is a suggestive rationale. That's at page 218, still in this tab. You'll see at the third paragraph, it refers to what the Secretary of State said in that email on the evening of the 28th of March. The fourth paragraph, it's felt that detaining the yacht would send a message to the Russian oligarchs with the aim of damaging support for Putin and limiting resources available to the Russian state. It's not quite clear from that who that was felt by. This may be a reference to the informal and formal discussions between officials that are described in paragraph 2. Then in the fifth paragraph, we have 500 super-rich Russians control more wealth than the poorest 99.8% of Russians and 40% of the country's household wealth. But then concedes that Mr. Nemenko may not be one of them. He isn't. Then read the 6th and 7th paragraphs. Invite the court to read those as to what it seems to have been thought at this stage that this might achieve. The court then comes forward to page 221, it's behind tab 33. On the 8th of April, this is a memorandum that goes to the Minister of State, Robert Courts MP, and his response. He agrees with the detention whilst we obtain further evidence. It's essentially a holding decision until then, and he says, we do need to consider this fully in the round, once that is obtained, and come to a properly evidenced decision. Behind tab 34, page 222, this is essentially just repeated by the Assistant Private Secretary. And then the notice of the decision is at page 223, behind tab 35. It's also in the core bundle, but again, we can stay with the copy in this bundle. It's an email of the 11th of April. It says, it opens by saying that Mr. Nemenko accepts that he owns, controls or operates the vessel, then goes on to deny, in the second paragraph, the Secretary of State has become the bailer of the vessel, or that it's at risk where it is. Denies that the Secretary of State made any defamatory statements, noting that the Secretary of State hadn't mentioned Mr. Nemenko's name while being interviewed in front of his yacht, and referring to its owner as a friend of Putin. It says the Secretary of State would be happy to consider any evidence Mr. Nemenko may wish to present in writing in relation to the continued detention of the vessel. Now, one turns to Mr. Driver, again, to see what he says about this. And that's at paragraph 66 of his statement. No, I'm talking nonsense. That is at page 66 of the bundle. Paragraph 102. He talks about the decision. And then he addresses what Minister Court said about further evidence. And as much as he can say is that this was made in the context of the approval of the draft response in which the Department for Transport invited the claimants to make representations. It's obviously right that it's in that context, chronologically. In any event, what Minister Courts seem to say, and his memo is reproduced in paragraph 102, what that seems to be saying is that there is not, at the time, basis for a properly evidenced decision. We'll get some further evidence, and once that's been obtained, we'll come to a properly evidenced decision. And then over the page, paragraphs 105 to 106, he addresses the point about a generic argument being relied upon, and he says that the rationale, which the court looked at a few moments ago, has the relevant detail. There is no absence of an individualised assessment. And where that's described as an individualised assessment, I don't think takes things very far. The reality, expressly acknowledged in the submission, is that officials had no specific information to go on about Mr. Nemenko or his situation. And they made their assessments on the basis that he was a generic wealthy Russian. That's the second decision. The third decision, a little over a month after that decision, on the 26th of May, there was still further correspondence on behalf of the appellants. That begins at tab 36, page 225 in this bundle. We don't need to read all of it. It deals principally with the last paragraph of the decision email, talking about evidence. They make some points about bailment and media comments. It notes that the Italians had decided not to detain the sister vessel. And then page 226, it turns to talk about Mr. Nemenko's situation, about his business interests and registration of the vessel in Malta. Over the page, it talks about the technical problems that arise as a result of detention, impossible to have warranty work completed, and then goes on to give details of Mr. Nemenko's business interests in page 5. Don't need to read all of them. They're at page 230 to 232, 228 to 232. And it explains how he's worked his way up through various regional businesses in post-Soviet Russia. Shareholdings, founding companies, selling companies. And then page 233, there's a copy of a statement that had been prepared for the Maltese authorities. I just invite the court to read from the fourth paragraph, that's if I had any sort of contact with V. Putin, down to the end.
Yeah.
After that, there is some fairly extended correspondence about licensing to get the yacht repaired. It culminates in a lengthy letter with attachments on the 1st of December, which the court will find behind tab 45, page 282, which I will summarise rather than take the court all the way through. That raises, in broad terms, the degradation of the vessel and what that was going to cost the owners, and also the safety of the vessel, emergency vehicle access to where it's berthed in Canary Wharf and so on, and in that context the difficulties that were being experienced. Now, by this time, Mr. Shapps had been succeeded first by the Right Honourable Anne-Marie Trevelyan MP and then by Mr. Harper. So on the 13th of December, a submission was prepared for Mr. Harper on the continued detention and repair operations options. And that's behind tab 46, page 292. Paragraph 2. No recommendation one way or another, but the Secretary of State is asked to decide whether to continue to detain the fee, considering the rationale and the outcomes of the review of continued detention undertaken by officials. And then paragraph 7, the penultimate line on that page. Officials assess continued detention of the fee continues to meet the purpose of the regulations and is still in HMG's strategic interest. Given its release, it could act as a signal that HMG is softening its approach to sanctions. DFT has also detained 3 aircraft whose detention may be questioned if the fee is released. Forward to page 297. This is an updated form of rationale for continued detention of the fee. Paragraph 3. Detention continues to meet the purpose of the regulations. Paragraph 5, towards the end of that paragraph, 4 lines up from the bottom. Officials considered that at the time of detention, the fee's owner had accumulated a level of wealth that, combined with his Russian residency, suggested significant economic activity in Russia which would be beneficial to the regime. This continues to be considered the case. Paragraph 6. If I could just invite the court to read that paragraph.
Yeah.
And over the page, page 7, it was thought that Mr. Nemenko may respond by criticising the Putin government, but this has not occurred, and is unlikely to, as Mr. Nemenko, through Warden Mackenzie, maintains there is no connection between him and the regime. Then at paragraphs 9 and 10, we have some references to proportionality. Paragraph 12 briefly talks about alternatives and notes that releasing the ship would likely be seen as a relaxation of the UK's application of regulations. This option is therefore unlikely to meet the purpose of the regulations. Of course, if the earlier detention was wrong, that would be an irrelevant consideration. It would allow an earlier illegality to taint the later decision. Over the page, paragraph 18, maintaining the detention of the fee would be consistent with previous decision making, with HMG policy on Ukraine and with allies. The point about allies is at the very least incomplete because allies, such as the European Union, had evidently not followed a policy of detaining vessels, save in sanctions designation cases. We look at what Mr. Driver says about this in his first statement. This is page 71 in the bundle. paragraph 116. Says evidence relating to the ownership of the fee was considered to still be reliable, and thus the fee still fell within the scope of the connected with Russia provision. Indeed, that has never been disputed. Then goes on to talk about the evidence about Mr. Nemenko's wealth that had been provided by Warden Mackenzie. And paragraph 119, it says as a result of that information that had been provided, they concluded that this did not need any further information about his individual sources of wealth. Did in no way lessen the evidence base and ongoing case of proportionality. One gets just a little bit more in Mr. Driver's second statement. That's behind tab 6, page 101. I'll just invite the court to read paragraph 8 of that statement. And he concludes that paragraph by saying decisions are made on a case-by-case basis. And that has to be set in the context that in March and April, the Department for Transport barely knew who Mr. Nemenko was. They had no detailed information.
Well, I mean, paragraph 9 is significant, isn't it?
Well, it's significant insofar as by the time that one gets to the December submission and the January 2023 decision, there is more material available upon which the Secretary of State can reach a conclusion that he's doing something that means he's very wealthy.
Well, it's not just very wealthy, it's that the level of wealth went significantly beyond that acquired in the ordinary course of business.
Well, he owns an expensive yacht. I don't think anybody can argue with that.
Well, it's a very expensive yacht, yes.
If I may just follow up what my lord has said, as always, we always have to read documents as a whole, don't we? Because there's a lot of further information which Mr. Driver deposes to in the following paragraphs. Paragraph 11, paragraph 12, he refers to the system of patronage, which is the subject of the respondent's notice.
It is, yes.
Paragraph 14, he's necessarily benefited from the economic conditions which have subsisted under President Putin's regime. Paragraph 15, actively or through tacit acceptance. Paragraph 16, retaining the loyalty of high net worth individuals, even the middle classes, is important for ensuring the stability of the Russian regime.
Yes.
So it's not just one or two bits of evidence, is it?
That there is an assessment made across a range of materials.
Yes.
Very little of it in my submission relating directly to Mr. Nemenko, but there is an assessment of a class of people into which Mr. Nemenko is slotted, if I can put it in those terms.
Yes, thank you.
So that's...
Has Mr. Nemenko given evidence as to his source of wealth?
Lord, he hasn't provided a witness statement in these proceedings. There are some details provided, for example, those documents that I showed the court a few moments ago about how he made his money, about his shareholders and so on. Some of that is explained
It's the
further.
letter, really. the letter you showed us a few
Yes.
minutes ago. That's all there is.
There are some references in the witness statement from Serene Collette of Warden Mackenzie. I can dig those references out of the short adjournment.
Thank you.
Moving then to the grounds for appeal, which I'm going to take in this order. I'm going to start with what the appellant says the proper purpose that confines the exercise of the power. That's ground 2. Then the decision to detain in March 2022 and how that was expressed, so grounds 4 and then ground 3. Then the nature of the April 2022 decision to detain and what falls from that, that's ground 5. Then look overall at the question of proportionality. I'm mindful that the course heard a lot of helpful submissions about the principles from my learned friend Lord Anson. And then finally conversion, which is ground 6. Starting then with ground 2.
So do you say that Sir Ross Cranston got the law wrong?
My Lord, yes, in ground 2.
So you're going to tell us right away?
Yes.
Good, thank you.
If I could start with the authorities bundle, tab 11.
Just tell us how you got the law wrong quickly, could you?
Lord, we say that he was wrong in his analysis of the purpose for which Regulation 57D power could be used.
Which paragraph? I'm looking at his judgment.
Yes, my Lord. I think the key paragraphs are 63. And then he draws the conclusions from that and his further analysis at 69.
So he was wrong that there are distinct regimes.
No, but he drew the wrong conclusion from that.
Just show me the passage where he draws the wrong conclusion. It's a fairly basic appellate advocacy point. What did the judge get wrong? Where does your screwdriver get into this judgment to say it's wrong? I know we may be able to do something even if he didn't get the law wrong, but I'm interested where he did.
Okay, Lord. The judge admitted when he made that point about the distinct regimes to identify the connecting feature between the two regimes, namely that they are both directed to the same purpose. This ground of challenge, Lord, is substantially about the interrelation between the designation powers and the detention powers in the regulations, and between the different shipping powers in Part 6 and how they illuminate each other. I can just stay with the judgment.
I find 5.1 in your grounds of appeal a little bit opaque. What is it saying? Just in words of one syllable?
Lord, may I turn that up? Well, Lord, I'm going to take, that may make more sense if I take the Lord to where this phrase broad sectoral measures, which appears in the judgment, comes from, and what that means. But what that's really getting at is that Regulation 57D contains a permissive power, and the use of that power, what Parliament intended to be done, the circumstances in which it was intended to be exercised, were directed, and we saw this in some of the legislative materials, at an effect on the Russian shipping sector, rather than at a particular Russian ship. Still less at a particular Russian individual who happens to own a ship.
Where do you get that from?
Lord, I'll take you to that, if I may. I think it's convenient to stay in the judgment for now. So,
Well, you made that submission below, did you?
I think Mr. Giffen made that sort of. Mr.
Yes.
Giffen,
But
made that submission
you
below.
were there. You were there. And where does he record it?
So
Is it paragraph 68?
it is, my lord. The maximum pressure in a wide variety of ways. So, paragraph 66 of the judgment, the judge says that Parliament created the power of designation. That included a power to designate people because they were connected to a particular country to achieve a broad and deep impact. And that phrase, broad and deep impact, the court takes up authorities bundle, tab 56, page 2274.
The answer to my question now, as I understand it, is that the criticism of the judgment is in paragraph 67 and 68, as said expressly in paragraph 5 of your grounds of appeal. That's the real complaint, the guts of it. And it's all based on purpose.
Yes, this ground is all about the purpose.
Effectively an implication into the legislation
Lord, yes.
as to the purpose.
Exactly.
Okay. Now,
And
you wanted to go to where?
Lord, authorities bundle, tab 56, 2274.
(2274).
In fact, Lord can start over the page at 2275. This is a letter from Minister of State in the Foreign Office to Lord Pannick in November 2017, when the sanctions legislation was making its way through Parliament. And that's where this broad and deep phrase that appears in the judgment comes from. So the fourth paragraph talks about broad sectoral measures. And then at the end of the sixth paragraph,
Which page are you on?
2275,
Right.
under the heading Persons Connected with a Specified Country. And it talks about the need for this type of sanction to have a broad and deep impact to bring about change in behaviour. And the judge, paragraph 66, makes reference to that. He says if you're looking at what connected to is in order to achieve, notwithstanding this is connected to in the designation context rather than connected to in a detention context, which is quite clear are distinct regimes, that it must be going to the same point. But of course, designation and the designation regime subject to a different and additional scheme of safeguards. Full statement of reasons have to be provided, system of exceptions and so on. And above all, Regulation 6.2. The Secretary of State must be satisfied that to designate the person who's going to be affected is an involved person. Not just that there may be some possibility of a contribution to changing Russia's policy in Ukraine. Nothing in the designation provisions makes personal wealth, even extreme personal wealth, without law, a basis for taking control of somebody's assets. And the submission made in relation to that, and this is the basis for that observation about distinct regimes. The submission is that it can't have been Parliament's intention that there would be a suite of safeguards to freeze a bank account with £100 in it, but at the same time to enable detention of an expensive yacht solely on the basis that the owner holds a Russian passport and was able to buy that yacht.
Sorry, just say that again. I don't understand what you're saying. You're saying it can't have been the intention to do what to a bank account with £100? Not to.
Lord, Parliament introduced the designation regime. Yeah. When it did that, put a whole suite of safeguards around the exercise of that power.
Yeah, and there's none for this.
There is substantially less, and that must be an indication as to how Parliament expected that power to be exercised. And the answer in my submission is this point about targeting matters at the sectoral level. I took the court earlier.
But where do you get the sectoral level from?
Lord, that comes from, we're in Authorities Bundle at tab 55, page 2263. This is one of those statutory reports. 2263. 54. Correct.
Paragraph 11.
Paragraph 11. All about the importance of global trade in goods. Vast majority going that way. Disruption to Russian shipping. That's why shipping is a crucial field in which to have a power to detain.
If you detain one ship, why isn't that disrupting Russian shipping?
Well, it's obviously not necessary in order to disrupt Russian shipping to detain every Russian ship. It's obviously not necessary to detain an enormous a substantial majority of Russian ships.
I mean, the point here that seems to be missing is the iconic nature of the vessel. I mean, I don't know how much super yachts cost, but as I understand it, this is an expensive one. Am I right?
Lord, yes.
Yeah. I mean, a very expensive one, the best in class.
I'm not sure how one.
So do you say, well, let's assume it's a very good one. It doesn't have to be the best. went to an exhibition, as I understand it. That was the idea. I mean, what do you say that the sanctions regime doesn't contemplate detaining an iconic vessel as something to disrupt Russian shipping and thereby send a message? Do you say that's not open to the minister?
We say
under this
we say it's
regime?
not. I can address that in two ways.
Yeah.
The first point is a simple factual one. The thing that has done most to make the Fee an iconic ship is its detention and its maiden voyage from the builders, and it's being kept alongside in Canary Wharf.
Okay, well, I'm sorry about the word iconic. A very expensive vessel.
The second point is that Regulation 57D does not exist in isolation. It interacts with Regulation 57A in particular. And one sees that submission having been made in paragraph 64 of the judgment, where the judge first to Giffin's submission that Regulation 57A was the first and logically foremost provision, with Regulation 57D falling in under it. And in my submission, Lord, that's the correct interpretation of the scheme. 57A, as I put it, going through the legislation, enables the Secretary of State to keep out Russian shipping, to deprive them of the use of British ports. And 57D is an enforcement mechanism in substance.
But he says, from a reading of Part 6 as a whole, there's no support for this. Each of the powers stands on an equal footing. I mean, do you challenge that? It's not in your ground of appeal.
Well, they stand on an equal footing insofar as that they may each catch different vessels. I don't know that the taxonomy of equal footing or not equal footing greatly helps. It will depend inevitably on circumstances as to which of those powers is of greatest use. One would perhaps think about it chronologically. At the time when the regulations are made, there may be Russian ships making their way across the sea, which will suddenly be told by the introduction of Regulation 57A that they can no longer berth in the UK. As time goes by, inevitably fewer Russian ships set out hoping to berth in the UK. Some may come here in an emergency, at which point a Russian ship finds itself in a British port, and there is then a question as to whether a power of detention should be exercised. Question as to whether it should be directed to go somewhere else. Each of those powers then falls and becomes available at that stage. So I don't know, in my submission, the logically coming first is not necessarily a helpful way to approach this, save perhaps crystallising at this very moment in time where it happens that at the moment the legislation is introduced, there is a Russian ship here, by happenstance.
Okay, well that might be a convenient moment to pause. How are you doing in terms of timing? I think you've made some good progress. You've obviously got the other grounds of appeal to deal with.
So I think 3:15 is doable.
Doable, excellent.
With Lord Anderson's following wind.
Well, he had a following wind, so I'm sure the wind is still blowing both of you. Thank you. 2 o'clock.
All right.